Good morning and welcome to today's oral arguments. Before we begin, I want to take the roll call of commissioners. Commissioner Belser.
Present.
Commissioner Hamilton.
Here.
Commissioner Irvin.
Here.
Commissioner Howard.
Here.
Commissioner Whitfield.
Here.
And we're all present and accounted for. Okay. Mr. Butler, will you read the docket, please?
Yes, sir. Thank you, Mr. Chairman, members of the commission. Good morning to you and to the parties. These oral arguments are being presented pursuant to Commission Order number 2020-549 and docket numbers 2019-290-WS and 2020-106A. Mr. Chairman and other members of the commission, the dockets are in order.
Thank you, Mr. Butler. We'll now take appearances from the parties. First from Department of Consumer Affairs.
Yes, good morning. Roger Hall and Carrie Gruby-Leibbarker with the department.
Thank you. Welcome. Town of Irmo.
My name is Jake Moore, counsel for the town of Irmo.
Thank you. Welcome. Blue Granite.
Mr. Chairman, Frank Ellerby and Sam Welborn are appearing for Blue Granite this morning.
Welcome. Thank you. Office of Regulatory Staff.
Good morning, Mr. Chairman, members of the commission. Representing ORS is myself, and I also have Chris Huber here with me today. Thank you.
Okay. Thank you, Mr. Bateman. Okay. Mr. Knowlton.
Yes, thank you, Mr. Knowlton, present. Thank you.
Thank you. Welcome. And representing York County.
Good morning, Mr. Chairman. Michael Kendry for York County.
Mr. Kendry, welcome.
Thank you.
All right. Now, we've done that. So now we will recognize Mr. Hall from the Consumer Affairs to do the first argue.
Good morning. Thank you, Mr. Chairman and commissioners. Again, I'm Roger Hall, consumer advocate with the Department of Consumer Affairs. I and DCA's consumer advocate, Carrie Gruby-Leibbarker, would like to thank you for scheduling this hearing. So
we want to make sure, Mr. Hall, make sure you got your mic turned, or you're kind of weak on the, we need to hear you better.
Okay. Is this better?
No.
Not really.
What about now? I think I've got it. Maybe I can get it.
Still kind of weak. You better speak loudly.
Okay. If I start yelling, just let me know.
That's okay.
Well, again, I'm the assistant consumer advocate with the Department of Consumer Affairs. With me is Carrie Gruby-Leibbarker, our consumer advocate. I want to thank you all for scheduling this hearing so that we can discuss the issues raised in our August 7th letter regarding Blue Granite's request to implement rates under bond. The purpose of our letter was twofold. First, we are seeking clarification on the bond approval process and the rights of parties related thereto. Second, we wanted to encourage the parties to find a solution to spare Blue Granite's customers any sort of rate increase during the COVID-19 pandemic. Today, I'll attempt to flesh out those issues and will present various options we believe exist to at least lessen the burden on Blue Granite's customers. The best case scenario in the department's mind would be for Blue Granite to postpone any rate implementation until after the governor lifts the COVID state of emergency or otherwise lets it expire. Section 58.5.240D states the utility may put the rates requested in schedule into effect under bond. Of course, there are additional parameters and a role for the commission to play in the implementation of this process, but I'll address those later. Right now, I'd like to focus solely on Blue Granite and the power they have to save their customers from undue stress of a rate increase during this unprecedented time. As the ability to request implementation of rates under bond is a voluntary one. Thus, withdrawing such a request is fully within the company's abilities. The company seemingly recognized the impact of COVID-19 in South Carolina when it changed course back in March regarding its planned timeline for the implementation of rates stemming from the February hearing on this matter. On March 13th, the company wrote a letter to the commission regarding quick implementation of any new rates. That letter stated, the utility's new rates are to be put into effect on an expeditious basis, immediately following the Commission's order on the merits, or in the absence of an order, put into effect automatically. The letter also indicated the company planned to include an ordering paragraph in its proposed order consistent with this position. When the company submitted its proposed order on March 18th, it proposed to notify customers of the new rates via a bill insert at the time the rates are made effective. In other words, no notice would be provided to customers until they receive their higher bill. Also on March 18th, the Commission sent letters to the Governor and the Legislature asking each to delay or stay all deadlines in 58.5.240, including the issuance of the order in this case. Both letters stated this request was being made, quote, so that ratepayers will be spared the possible economic effects in these troubled times. Blue Granite swiftly revised their position after the Commission submitted these letters. On March 19th, one day later, the company informed the Commission that it was willing to delay implementation of new rates until September 1st if the Commission issued its order in this case. That letter stated, Our proposal to delay the effective date of the new rates is not conditioned on any particular outcome in this proceeding. Whatever rates are set by the Commission in this docket will not be put into effect until September 1st, 2020. I don't think any of us anticipated in March the broad negative financial impacts this unprecedented health event has had on South Carolina, or that it would continue into August with no real signs that the health or financial concerns are going to get significantly better anytime soon. Recent studies and articles show that the effects are still being felt. I'm going to try to list just a few. On August 20th, the South Carolina Department of Employment and Workforce released statistics stating, for claim week ending August 15, 2020, the number of South Carolinians who filed their initial claim for unemployment insurance benefits is 7,255. That's an increase of 1,334 initial claims from the week prior. The press release further stated this brings the initial claims total to 719,704 received since only mid-March. Based on the county-by-county breakdown they provided, many of these are in Blue Granite service areas, with the highest numbers in Richland and Greenville counties. The Aspen Institute Financial Security Program and the COVID-19 Eviction Defense Project estimate 205,000 to 273,000 households that rent in South Carolina are at risk for eviction. This accounts for 471,000 to 628,000 people and represents 35% to 52% of all renters in the state. Studies from IBS World and Oxford Economics found South Carolina is particularly vulnerable to financial impacts of the pandemic, ranking the state second and sixth highest respectively. One of the studies noted 70% of all employees in South Carolina are employed in sectors that have high or medium-high levels of economic exposure to COVID-19, totaling 1.7 million employees. The other noted South Carolina has the 10th oldest population in the country. The picture that these statistics paint is grim, showing the real impacts on South Carolinians. Therefore, we would encourage Blue Granite to revise a plan to implement increased rates and await the expiration of the state's emergency status. Should the company fail to do so, however, it is the department's position that COVID-19 pandemic provides an avenue for the Commission to delay implementation of the rates. The legislature provided this Commission with broad authority to ensure that what is implemented in practice or policy is just and reasonable. Specifically, Code Section 58.5.290 requires the Commission to reject what is unfair and unreasonable, including unfair or unreasonable rates, rules, or practices, quote, however or whensoever they shall have been fixed or established, and instead to order what is fair and just. Further, Section 58.5.300 empowers the Commission to, quote, consider all facts which in its judgment have a bearing upon a proper determination of the question, even if such facts weren't included in the application. This authority is extended even to matters on which the Commission already ruled and issued an order or decision. Section 58.5.320 grants the Commission the ability to, quote, at any time rescind, alter, or amend any order or decision made by it. The Commission has relied upon this law in the past. For example, in docket 2009-342-WS involving Avondale Mills, In that case, the Commission considered the negative impact previously approved rate increase would have on a town experiencing significant job losses due to the closing of a mill and the ramifications of the Graniteville chlorine spill. In that case, the Commission noted that it presented one of the most challenging and problematic sets of facts ever before us. A dissenting opinion further noted, the timing of Avondale's petition for rate relief could hardly have been worse, considering that both the national economy and that of South Carolina are in a recession. There were several other factors that impacted the Commission's consideration of possible resolutions, but the Commission ultimately allowed consumers additional time to pay any arrearages and prohibited disconnections, late fees, and interest. The South Carolina Supreme Court has also recognized the Commission's ability to act in this instance. For one example, citing 58-5290 for the proposition that the Commission must correct unjust or unreasonable rates, the court stated in Porter v. South Carolina Public Service Commission, quote, clearly under statute, the Commission has the continuing power to prospectively correct or reduce a previously approved charge. Excuse me. Today, all of South Carolina is in the midst of an unprecedented crisis. The governor's August 10th executive order extending the state of emergency in the state summarizes it well when stating, quote, the COVID-19 pandemic represents an ongoing, evolving, and expanding public health threat, which requires that the state of South Carolina continue to take all necessary and appropriate actions in proactively preparing for and promptly responding to the public health emergency and the significant economic impacts. If there ever were a time for this Commission to find that increasing utility rates that are unfair or unjust, it is now. The other primary reason for the Department's August 7th letter was to seek clarification regarding the status of the bond approval and the ability of the company to implement new rates on September 1st. Section 58.5.240D allows a company, should they so choose, to implement rates under bond pending final determination of the appeal. While the statute limits the Commission's role in the bond process, it still charges the Commission with making certain determinations for the protection of the parties. These determinations include approval of the bond amount and surety company, as well as setting refund parameters. The law specifically states that refund parameters shall be prescribed by an order. It is clear from the statutory language that the legislature did not intend for the bond process to be one of automation. Instead, they set up the Commission as the reviewer and final approver of the company's submission. We have researched past Commission decisions related to bonds. In every example we found, the Commission issued an order. We did find two dockets where directives were issued. However, soon thereafter, orders detailing the findings behind the directives were issued. Those were dockets 2007-286-WS and docket 2014-346-WS. Further, those two directives addressed the customer refund component of 58.5.240D in some manner, unlike the current directive. We acknowledge that the Commission at times does issue directive orders. In those cases, an order number is included at the top of the form, and the following statement is added in all caps and red font. This directive shall serve as the Commission order on this issue. That is also not the case here. The determination of whether the Commission's directive constitutes a final order decision here is important, because a final decision triggers certain rights for the parties under various statutes and regulations. For a few examples, Section 58.5.330, rehearing by the Commission, states that within 20 days after an order or decision is made by the Commission, any party to the action may apply for a rehearing. Section 58.5.750, appeals, states that any party in interest being dissatisfied with an order of the Commission may appeal as provided by statutory law. And Regulation 103.854 provides that any party of record may, within 20 days after the date of receipt of an order, petition the Commission for rehearing or reconsideration. Notably, the Commission regulations define order, but not directive. Based on the past precedent whereby the Commission issues orders for bond matters, or generally issues directive orders, we do not believe the directive, which is essentially the approval of a motion, is the final Commission decision, and we consider the bond request pending. Thus, it is the Department's position that Blue Granite is not authorized to begin implementing the rates under bond on September 1st based on the issuance of a directive. A final determination must be made. even if the Commission finds it cannot prevent a rate implementation under bond or cannot revise, amend, or rescind its previous final order, 220-306, the Commission should require that Blue Granite only implement rates that have already been approved. This is what Blue Granite proposed in its March 19th letter. The Commission relied on that proposal when it issued Order 2020-260, agreeing to issue a final order in the matter. Order 2020-306 contains the only rates that have been approved by the Commission. In closing, as stated earlier, we feel the best case scenario would be for Blue Granite to postpone any rate implementation until after the governor lifts the COVID-19 state of emergency or otherwise lets it expire. Other potential options might include allowing Blue Granite to implement the rates found in Order 2020-306 or phasing in rates. These options are by no means exhaustive. They are just merely avenues we identified as the most impactful and feasible. We implore the Commission and Blue Granite to find a creative solution. The pandemic has been a moving target, producing circumstances that no one can predict. In writing legislation, the General Assembly is aware of its inability to consider all possible circumstances, events, or sets of facts to which a statute might apply. And looking to sections 58.5.290, 300, and 320, it is clear that the intent of the legislature was to provide this flexibility and to ensure fairness and reasonableness. The legislature entrusted the Commission, who would be privy to the unique facts or unusual circumstances, with the tools to make this so. Even if the directive is the final decision of the Commission on the bond request and an appeal is no longer allowed due to the time constraints in the statute, the Commission has authority to change its decision and delay implementation of any rate increases during the COVID-19 pandemic. Thank you for your time. I'll be happy to answer any questions that you have. Thank you.
Thank you, Mr. Hall. Commissioners, questions for Mr. Hall?
Mr. Chairman.
Commissioner Belser.
Good morning, Mr. Hall.
Good morning.
How are you today?
Doing well, thank you.
I have a few questions. I may come back later and ask a few more, but you indicated that that y'all filed a letter, one, seeking clarification, and two, to encourage the parties to reach some sort of agreement to lessen the burden on customers. And my question is, has the Department of Consumer Affairs reached out to Blue Granite and Office of Regulatory Staff and Town of Irmo and other parties to see if some agreement could be reached?
We have reached out to Blue Granite a couple times. We spoke with their counsel.
Okay.
Yes, didn't really make much headway.
Okay. You cited to a case of Avondale Mills, and I did not review that case, but I will. And you also cited to the Porter versus Public Service Commission case. I believe that was in reference to 58-5-290. I think that was a 1998 case. Is that correct?
Let me double check.
And I think I might have been staff counsel on that one.
I think it was, yeah, I believe it was at the Supreme Court in
and it was a Carolina Water Service case, was it not?
Yes, I believe so.
And that correction of improper rates, I believe, wasn't that a situation where the consumer advocate asked that a rate be reduced during the rate case? The commission said it was a previously approved rate and therefore did not and declined to adjust it lower. And the court said the commission erred in that and should have reviewed it and reduced it in the context of that rate case. Is that correct?
Yes, that's correct. I believe a big part of that issue was the authority of the commission to act versus the authority of the courts to act. And I believe the court did say, yes, the commission had the authority and supplemental authority beyond what's specifically mentioned in the statute to make those types of decisions.
Okay. I want to look at, do you have your letter of August 7th with you? I want to go through a couple of points in that if you have it with you.
Give me just a second to pull it up. Okay.
Okay. You acknowledge that this is the first instance of your department having exposure to the bond process and you're seeking clarification. And then in the second paragraph, you state the department pondered whether the directive constitute the final decision on this matter, whether the commission intends to issue an order reflecting the July 15th vote. And you've gone through a discussion of directive versus directive order. And the July 15th directive does not have an order number, is that correct?
Correct.
And it does not have phrasing at the top that says this is a directive order or constitutes the order of the commission. So without those, would you accept for clarification that if it does not have an order number and does not have that statement that this is the order of the commission, that a written order will be forthcoming? Would you accept that?
Yes.
Okay.
Yes, and we have seen that language in the past. While this one doesn't explicitly state that, that was the assumption.
Okay, it may not always explicitly say that, but if it doesn't have an order number and doesn't have that language that this is the order of the commission, then an order will be forthcoming. And let's see. I'm on the second page now, and the letter states, we suggest implementation could be delayed either voluntarily by the company or by the commission pursuant to its inherent authority. I'm curious as to what inherent authority this commission may have, because generally I think the commission is viewed in the case law as the Public Service Commission is created by statute, and its authority is limited to that granted by the legislature, which are the statutes in Title 58. Would you agree with that?
Yes, and I believe here that not only is the authority being inherent just in setting fair and just rates, but it's actually explicit as well in statute under 58.5.320.
Okay.
The state commission at any time may alter, amend, or rescind a prior decision.
But doesn't that require notice and an opportunity to be heard? Doesn't that constitute a hearing process? Or not constitute, but envision a hearing process?
I believe it does. It does say that upon notice and opportunity to the utility affected. I guess you could argue this is one opportunity for them to be heard. Certainly if the commission felt that an additional hearing was needed from Blue Granite, we would understand that.
You provided some materials to Mr. Butler last night, and I believe you also provided those to the parties in this case as well. Did you not?
Yes, ma'am, I did.
And one of the documents you provided was a copy of the Governor's Executive Order 2020-53. Does that sound familiar? And that order, that executive order is now no longer in effect. Is that correct?
I believe that one is still in effect. That was issued or filed August 10th.
It was August 10th, and it says shall remain in effect for a period of 15 days. What's the date? But would you accept, subject to check, and just from the articles, that the governor has issued a subsequent executive order?
Yes, that's correct. I do believe he has issued a subsequent order. I'm not as familiar with that one. I've not had a chance to really review it. But I believe we are still under a state of emergency.
And you referenced the fact that the commission had issued or sent a letter to the governor and to the General Assembly leaders asking for them to take action on the statutory scheme under which this commission operates back in March.
Yes.
Okay. Anywhere in these executive orders does the governor stay or suspend any of the statutes under which this commission must operate?
Not in the one that we referenced. Again, I haven't seen the most current one, and I don't believe they took any specific action, as far as implementing a stay based on the commission's letter. I remember the timing in my head. I do believe that they, requested that, utilities suspend disconnections, things of that nature, but I do not believe they ever specifically addressed staying any of the deadlines in Title 58.
And Mr. Hall, I'm not trying to be argumentative, or I'm not trying to argue any party's position. I'm really trying to get a grasp of the parameters that we can operate in. So that's why I'm asking some of these questions. So just so you know.
I understand. Ask away.
Thank you very much. I keep coming back to I keep coming back to a thought, and let me just throw this out there and you can respond. Is what you are asking us to do, is it in the, are you asking us to basically provide an equitable remedy here? And the reason I'm concerned about that is because I believe that when there is a and you please disagree with me on any point or correct me if I'm wrong, but if there is a statutory scheme in place, then a remedy in equity doesn't really lie. Would you agree with that statement?
I do, and I don't think it's necessarily an equitable request to the extent that the commission's, directed the authority given to the commission is to set fair, just, and reasonable rates. I think, arguably, given that this pandemic has continued the way it has, if in March, or excuse me, at the end of February, when this matter was heard, if we realized that this pandemic was not getting better from financial aspects for citizens or health aspects, that would play a factor in setting what is fair, just, or reasonable. I think the statute again gives that explicit authority. The other issue, so one alternative, right, was that we suggested was some sort of delay. I think the other, which was again based on Blue Granite's own proposal, was to only implement rates that have been set by the commission. The letter when the commission wrote to the governor and the legislature, there was a real possibility that they would have implemented an indefinite stay of all timelines in 58.5.240, including the issuance of an order in this matter. Blue Granite proposed, please issue the order. We had the hearing. We went through all this trouble. Issue the order. If you issue the order, it doesn't matter what you say. This is their words. The decision, it does not matter what decision comes from it. We will only implement whatever rates are set by the commission. To me, that was their proposal. The commission accepted that when they said, okay, we'll go ahead, we'll issue our opinion in this. We accept your proposal. And then we turn around September 1st, or excuse me, when they moved for the bond, motion for implementation of rates under bond, said, no, we're going to implement whatever we want. They did not implement what the rates set by the commission.
And Mr. Hall, that you're referencing Blue Granite's March 19th letter,
yes.
Where they responded to some of the COVID issues. Is that correct?
Yes.
Okay.
And that was, again, the day after the commission's letters to the governor and the legislature requesting an indefinite delay.
Okay, let's look back at 58.5.240, and you indicated that the 240D, where the bond is referenced, and you stressed the word may, that it is a permissive, but do you agree that it is the utility that decides whether or not to ask for rates under bond? I understand what you're saying about the March 19th letter. Let's just talk about 240D in a contextual framework, if we could. Do you agree that under 240D, it is the utility that chooses whether or not to try to put rates into effect under bond?
Yes.
And that this commission's authority under 240D with respect to that bond is to ensure that an appropriate surety and bond amount is set under that code section.
Yes, I do agree that the commission's role is somewhat limited, that typically the utility, has a right and I would say in normal circumstances. Again, I think it all comes down to, though, fair, just, and reasonable rates. I think the commission would have authority if the implementation of rates under bond was not fair, just, and reasonable to rule that way.
And, okay. That's all I have right now, Mr. Hall. Thank you for indulging me and answering my questions. Thank you. Thank you, Mr. Chairman.
Thank you, Commissioner Belser. Commissioners, any other questions? For Mr. Hall?
Sure.
Okay. Yes. I didn't hear who spoke up. Which?
Hear me?
No, we're breaking up here. Who's speaking?
It's Whitfield. Can you hear me?
Yeah, I can hear you now. Okay, Commissioner Whitfield.
All right, volume's up now. Can you hear me now?
Yes.
I do kind of have one follow-up for Mr. Hall. Mr. Hall, you had a pretty thorough exchange with Commissioner Belser, and she asked most of what I had in mind. She's very thorough, of course, as always, but wanted to kind of follow up with you. And I know you were candid in saying the department, your department is new to dealing with bond issues, and you were very candid about other matters as well. And she had a discussion with you between directives and orders and COVID-19 and previous cases and so on and so forth. But unless I missed it, what statute, other than the one you and Commissioner Belser were last discussing, 240D, what statute would directly allow the commission to deny the rates under bond?
58.5.320, I believe, is probably the most applicable. And
I think you did mention that earlier. Yes, sir.
I believe 58.5.290 also applies. And kind of sandwiched in between those, I guess, 55.300 actually allows the commission to consider all facts, whether or not they were set forth in an application. So again, we feel that is, the intent there is to say any unique, unusual circumstances that may arise that may lead the commission to decide they need to alter or amend a previous decision.
Okay, I'm getting there. So 290 and 320, and of course the discussion you had with Commissioner on 240. All right, thank you, sir. That's all I have, Mr. Chairman.
Thank you, Commissioner Whitfield. Commissioners, any other questions for Mr. Hall?
I do have.
Okay,
well,
Commissioner Belser.
Let me come back later.
Okay, Commissioner Belser's going to come back later. Mr. Hall, I'm just thinking out loud with your request or proposal. I know what the Consumer Affairs, you're focused mostly on the ratepayer, and and we have the duty to come up with fair, just, and reasonable rates for the ratepayer. We also have to balance the financial stability and integrity of the company. With COVID-19, we're sort of in a position where nobody really knows how long we're going to be in this state of emergency or in this predicament that we're in right now, which is causing a hardship on everyone. Just what do you, as y'all have been talking, how long have you got a feeling for it? If the emergency is lifted, we're still going to be in a situation where we're going to have a lot of hardship out there. Have you got a sort of a timeline in your mind as to when things might might ease off on everyone?
Unfortunately, we don't, and to try to be fair ourselves and to come up with some sort of time frame, I think that's why we proposed that until the governor, lifts the emergency order or otherwise lets it lapse. We trust that the governor and legislature are looking at these issues, looking at, impacts to the state, and if they're, still feel that the state is in a state of emergency from this, then we feel that the rates, the consumer should not be subject to higher rates. If the governor lifts the order, presumably they've looked at the issues and felt that, no longer as big of a threat either from a health standpoint or a financial standpoint.
Thank you. Thank you. Okay, commissioners, any other questions for Mr. Hall? Okay. Mr. Hall, thank you. We will move from Mr. Hall to Town of Irmo, Mr. Moore.
Thank you very, very much for the opportunity to speak today. I guess the seminal question is, because they have the right to apply for an increase under bond, does that mean that they can do it regardless what the facts and circumstances are? And I'd respectfully submit that the law should not allow for that. From what we know, we went through about a week-long trial, or at least what appeared to be a trial hearing, several months ago, where the commission, I believe, has issued a ruling. It would appear that the Blue Granite folks simply are dissatisfied with that ruling and are filing for a request under bond when the facts could not possibly and have not changed since the time of the commission's original ruling. I'd respectfully submit that the overriding principle of law as set forth in the code is, as the Department of Consumer Affairs states, that it's got to be fair, just, and reasonable. We have a situation where we have a major financial hardship on people who are already being charged through the nose for sewer service. We have a situation where we continue to have horrid service. We continue to have streams polluted. We continue to have manhole covers blowing up. We continue to have all sorts of problems from these folks. And we just finished with a rate hearing, I believe, several months ago. I seem to recall having been there and listening, and I have read with interest what the commission has done, which certainly makes good sense to me. These folks, I believe this would be the fourth increase in 5 years, and the worst service probably in the state of South Carolina and maybe the entire country, with maybe the possible exception of Flint, Michigan. The sewage charges we're getting are already out of line. We still don't have the metered readings. We still have the problem where Blue Granite is not even the operator of this system. Now, I do say that loud and clear. Blue Granite is not the operator of this system. Blue Granite is the owner of the system. The operator, from their own prior testimony, is Clearwater Company. So what's happening is Clearwater Company is making a profit and Blue Granite is making a profit on the operation of this system, which is a very artful way to, in effect, get around the regulatory charges set forth in the statute. The Clearwater Company is the operator of this system. Blue Granite does nothing to operate this system other than contract with Clearwater. And here we now have another charge under bond. Now, the statute does require or does authorize them, it says they may increase the rates under bond. But I would respectfully submit that we know an awful about the way they operate and the way their rates are set already. And the situation we have is that just because they may file under bond does not take away the overall authority of the commission to review whether their conduct is fair, just, and reasonable. I guess that would be subject to somebody smarter than me to be able to analyze what the statutes say, but my review of the statutes, which has not been as thorough as others, tends to indicate that the overall question and the overall purpose of the commission is to make sure that the conduct of the operator, which they're not the operator, they're the owner, is fair, just, and reasonable. First of all, our position is, since they are not the operator, that actually they shouldn't be able, they're the owner, but that's about it. But the conduct, considering the testimony we just went through, considering the continued horrid service that's being delivered, considering the overall history of these folks, considering the fact that we have all sorts of modest level incomes, retirees and so forth, being charged not on a consumption basis but on a flat rate, when Blue Granite is paying on a metered basis. So we've got people on fixed incomes trying to deal with the COVID virus. We have all sorts of emergency situations. We've had a present order now in effect from a hearing that took us a week to have, and here they come again trying to basically get around what's already been done by simply taking advantage of what appears to be a statutory authority that they can go ahead and increase the rates anyway, notwithstanding the prior ruling. That does not appear to me to be just, fair, or reasonable. We just continue to have polluted rivers, manhole covers blowing up, way out of line charges. The problem we have is that these people are never going to be able to operate this system. They'll never be able to do it on a reasonable cost basis because of the historical neglect they have made of the system. It's going to take a huge amount of capital investment to get the system running correctly. But the problem is they should have been spending money historically year upon year upon year, and they took the money themselves and didn't spend it on the operation and upkeep of the system. Now they're coming back under bond again and again and again, seeking outrageous sewer charges, which are way over the top, especially considering the financial strain on the public. It would certainly seem to me that under the commission's, and again, I stand to be corrected, and maybe Paul says they can just keep getting bonds, they can posting bonds and so forth, but I still think that what their conduct, the purpose of the commission is to ensure that everything is fair, just, and reasonable. The statutes basically say that. It would seem to me that their ability to file for a rate increase has to be a filing in good faith. If this commission finds that the filing under bond is not in good faith, then this commission, and I believe should find that the conduct of the utility is not fair, just, and reasonable, and should deny this and basically should continue on with the present order which has been issued. I'm sure that the utility continues to want more and more and more from the modest families they serve. I can think of a worst possible time to have filed for a rate increase during the COVID virus and directly on the heels of the order that the commission has just issued. I thank you for listening to me. I hope what I have said has been appropriate. Thank you very much.
Thank you, Mr. Moore. Commissioners, any questions of Mr. Moore?
Chairman,
Commissioner Irvin.
I have a couple of questions, please.
Yes, sir.
Mr. Moore, you mentioned the fact that the Supreme Court has lifted their eviction order. Is that they had put in an order earlier in the year, I believe, that prevented further foreclosures and evictions. Has the order been lifted now?
Mr. Commissioner, I do not know that. I know that it was set to expire, and I believe but do not know that the governor has extended that, but I stand to be corrected on that. I simply don't know.
Does Consumer Affairs know? Could I ask Mr. Hall?
I believe that they have lifted the eviction.
Seems that it expired in late July.
I believe that's correct.
Mr. Chairman, I'd like to get a late file exhibit, a certified copy of the Supreme Court's order as it relates to the eviction issue.
Okay, can we get that furnished? Mr. Butler was asking, can someone furnish that?
This is Roger Hall with the Department of
Yes, sir,
Consumer Affairs.
Mr. Hall.
We'd be happy to provide it.
Okay.
In addition, I'd like to ask Mr. Hall to provide us with a true copy of the governor's extended emergency order under the pandemic or COVID health pandemic.
Certainly.
And since they're set to expire, I think they expire every 15 days, so that would be an ongoing requirement. As long as we're under a governor's pandemic order, we're going to need to get true copies for the commission record.
I think we have that order, Commissioner Irvin. I think we got that.
All right, we make it a part of our record.
I think Commissioner Belser.
I think both the Supreme Court order on evictions and the governor's executive orders are public records. Would the parties consent to the commission just take judicial notice of those documents?
I would certainly consent. I think that would make all the sense in the world.
Speaking for the company, yes, we think that's a correct approach, take judicial notice.
This is Andrew for ORS. We agree.
Okay.
Mr. Chairman, would you go ahead and take judicial notice?
Yes, we will, Commissioner Irvin, we will take judicial notice of both of those and have that in the record.
Thank you, sir.
Thank you.
Mr. Chairman.
Yes, Commissioner Belser.
I think that it will be appropriate, just in an abundance of caution, that we'll talk with the hearing officer on this case and at least have the hearing officer send an email to all the parties indicating or with links to those documents so that they know what we're looking at, if that is acceptable.
Yes. Nods from everyone. Okay. Okay. Thank you. Commissioner Irvin, any more questions?
Not at this time. Thank you, Mr. Chairman.
Okay. Thank you. Thank you, Commissioner Irvin. Any other questions, commissioners? Mr. Moore. Okay. Hearing none, Mr. Moore, thank you for your participation and for your comments. We will now move to Mr. Ellerby from the company, from Blue Granite.
Thank you, Mr. Chairman and Commissioners. Appreciate you letting us speak to these issues. I am going to try to follow the three sections of Mr. Hall's presentation for the consumer advocate. The first thing he argued was that he thought Blue Granite should voluntarily postpone any increase. The company has, we declined to do that, and they're very good, compelling reasons, and it sounds like from some of the questions that the commissioners probably understand where we're coming from. Back in March, the company agreed to delay implementation of rates until September, At that time, we thought, and a lot of other people thought, that would give the economy an opportunity to recover. That delay, we've estimated, as indicated in the letter that we submitted in response to the Consumer Advocate's letter, that delay, we estimate, has cost the company $2 million in revenue. In addition, the company, we believe, was the first utility in South Carolina to suspend disconnections and to reconnect people who had been recently disconnected. And that was done by the company before the governor issued an order, before the governor issued his executive order asking this commission to act on that, and before the commission issued its order 2020-228. So Blue Granite has been sensitive to the concerns that the Consumer Advocate has discussed this morning, and Blue Granite has taken reasonable and strong steps that were significant in trying to help folks address these issues. However, as y'all know from having gone through the rate case, where the vast majority of the company's capital spending and operating expenses that supported our revenue requirement, the vast majority of it wasn't even contested by the folks in this case. The record demonstrates that the company has spent a whole lot of money trying to improve service, trying to add facilities, expand facilities, improve facilities. And we know that we have more work to do. And the company has an absolute obligation to improve its facilities and its operations to enhance service and provide reliable service. The company can't do that if the company can't recover revenues associated with those expenditures. I mean, that's just the basic fundamental rule here. It's part of what's referred to as the regulatory compact. The company spends the money, and then the company has to go before a utility commission, but the company has a right to recover its operating expenses, an opportunity to recover its operating expenses, and a return on its capital investment. So we respectfully decline to withdraw the effort to put rates into effect under bond. The next thing that Mr. Hall talked about was that the commission could act under 58.5, 290, 300, and 320. First of all, that any motion pursuant to those provisions or any effort to raise the consideration of what the commission could do under those provisions is not properly before this commission today. What those statutory provisions contemplate is a complaint being filed and a company being brought in. There would need to be notice of the complaint. There would need to be pre-filing of testimony, opportunity for discovery. Essentially, a full-blown rate case is what's contemplated by those provisions. I noticed that the Commission's regulations support that. The definition of petition allows folks to petition this Commission for lots of relief, but there's an exception for an adjustment in rates. Well, an adjustment in rates under Section 290 could not be done by a petition, could not be done by a motion in a case that's already been pending, and I don't think this letter really qualifies as a motion, and it certainly couldn't be done by the letter that was filed on August 7th by the Consumer Advocate. So the matter is not properly before this Commission. Second, on the merits of the proposal by the Consumer Advocate that the Commission act under those provisions, there is as has been discussed in response to questions from commissioners, there is a very clear statutory procedure that the company followed to put rates into effect under bond. It applies, the statute under section 58.5.240 only applies when the company has been in for a rate case and the company then has appealed by filing a petition for reconsideration. The company then can put rates into effect under bond, and the commission's role with respect to those rates is to approve the surety and to approve the amount of the bond. We filed our motion for approval of the surety and the amount of the bond on June 8th. There was no opposition. There was no opposition to our motion. The commission acted on July 15th and approved the surety and the amount of the bond. It wasn't until August 7th that the consumer advocate wrote a letter asking for clarification. That statutory procedure that's allowed under 58.5.240 is very specific, and it is more recently, if you compare, if you think there's a conflict between 58.5.290 and 58 and the rates under bond provision of 58.5.240, basic fundamental principles of statutory construction indicate that the commission would apply the provisions of 58.5.240 that I just described. First of all, section 58.5.290 was last amended in 1935. 58.5.240, the rates under bond provision was amended by Act 158 of 1983. In addition, a second also compelling tenet of statutory construction is that the more specific provision, if there is a conflict, and I'm not suggesting that there is a conflict, I think they can be read together, but if there is a conflict, the more specific provision, which would be 58.5.240 and its provisions regarding rates under bond, would apply, and whether under these circumstances the consumer advocate could file a complaint and open a new docket and a new proceeding with new discovery and new provisions under 58.5.290, I do not know. I haven't looked at that. I did not know until I began to look at Mr. Hall's authorities that he sent at 6:30 last night, where they were headed, and I began to suspect where they were headed, looking at those authorities. But we don't think they can do that, but that's a question for another day. What we know today is the company comes before this commission, or has come before this commission, to get the authority, to get the approval that we needed from the commission under 58.5.240. And y'all have given that approval on July 15th. The directive issued indicated that the surety and the amount of the bond were approved. The directive, when this matter was set for oral argument, indicated again that the surety and the amount of the bond had been approved. So the bond's been approved, and the company, we believe, has a clear statutory right to move forward. I'm moving into the third argument or proposal made by the consumer advocate, and that is what Mr. Hall referred to as clarification of the status of rates under bond. We have cited in our motion where we asked for approval of the bond, and in the letter that we filed with the commission on August 13th, responding to the consumer advocate, we have cited docket after docket where this commission has held repeatedly that it does not have any discretion with regard to the rates, approval of the rates going into effect under bond. That's what the General Assembly intended, because, and it makes sense. The commission, because we've appealed or in the process of appealing, the company is making a choice to implement rates that the commission did not approve in the rate case. And y'all know this, but just to remind folks, the company does that with the understanding that if our appeal is unsuccessful with respect to those rates, We stand to have to refund that money back to customers with 12% interest on the amount that is determined not to have been allowed after the appeal. So there is and this commission has repeatedly held that it does not have authority, and we did not ask y'all to approve those rates. We don't think that's within your statutory authority. We absolutely agree that your authority with regard to these matters is limited by what the statute provisions provide. You don't have equitable authority particularly to ignore the provisions of statutes that the General Assembly has adopted, and y'all would just to be consistent with your previous rulings, you would decline any effort to interfere with or to pass upon the rates that the company is planning on putting into effect that are protected by the bond. You do clearly have a role with respect to approving the bond, surety and the amount, but not with respect to the amount of the rates. The couple of other things, the governor, there's a significant question whether the governor under his emergency powers would have the authority to instruct the commission or authorize this commission to reduce rates of utilities. However, we don't have to get to that. We don't have to get to that question because the governor declined to do it. This commission wrote the governor and also wrote the General Assembly, and neither the governor through an executive order nor the General Assembly through any action by it took action on this issue. The General Assembly did not give y'all the additional authority to address these issues. The governor did not do that. There is simply, to sum up our position, there is no basis for the consumer advocates' request that y'all assert the jurisdiction to refuse or to try to countermand or cancel the rates that the company proposes. One last point, and that is the question of the directive versus the order. The statutory provision that we're relying on, 585240, specifically says the commission approve the surety and approve out of the bond. In the next clause, discussing the refunds, if there is a refund after the appeal, the statutory language specifically says by order of the commission. But with respect to approval of the surety and approval of the amount of the bond, the statute says approval, does not say order. We believe that y'all on July 15th approved what needed to be approved so that the company could move forward. We do not think that the commission could, simply by withholding the issuance of a formal order, prevent the company from moving forward with what is a statutory right to put rates into effect under these circumstances. And we've cited authority from the United States Supreme Court describing the compelling circumstances that can arise why a company needs to put rates into effect under bond. And the General Assembly has seen fit to allow the company to do that under certain circumstances. We've met the circumstances. We think it would be a dangerous proposition for the commission to hold that you have to wait for a formal order and then not move forward with actually issuing the formal order. There's not much to the issue before you. We've given you all a proposed order, but But we think the correct interpretation is, reading it strictly on the face of the statute, is that the matter was resolved when y'all voted 6-0 without any opposition from any of the parties on this call at this hearing, to approve the surety and the amount of the bond. So I'm happy to answer any questions. I appreciate you hearing me out.
Thank you, Mr. Ellerby. Before we get to commissioner questions, we're going to need to take a short break, and we will be back at 11:16. So everybody, please stay on the line. Just mute your phones, and then we will come back at a little bit after 11:15, and so we are in recess. Okay, welcome back, everyone. As is our custom on these virtual hearings, we'll call the roll for commissioners. Commissioner Belzer,
Present.
Commissioner Hamilton,
Here.
Commissioner Irvin, Commissioner Howard,
Here.
Commissioner Whitfield.
Here.
Okay. Commissioner Irvin. Oh, I thought he said something. Okay, I see him on the screen. Okay, we're good. With everybody. Got eyes on all of them. Okay, so we are at Commissioner questions for Mr. Ellerby, and I'm going to call on Commissioner Belzer.
Good morning, Mr. Ellerby.
Good morning, Commissioner.
I want to talk to you about a couple of things, or let's just discuss a couple of things. In your, I think it's your letter of March 19th. Do you have that with you?
It's here somewhere, but I think I can respond.
I'm having that same problem trying to dig through pages up here. Mr. Ellerby, I'm on the bottom of the first page in that last paragraph, and in that paragraph, about just below midway through, it states, in the meantime, Blue Granite would commit to not putting new rates into effect until September 1st, 2020. The delay would provide a period of approximately 4 months before any rate increases would take effect. Our proposal to delay the effective date of the new rates is not conditioned on any particular outcome in this proceeding. Whatever rates are set by the Commission in this docket will not be put into effect until September 1, 2020. Can you clarify, or can you respond to the assertion there that the company would put into effect whatever rates are set by the Commission?
Well, we were, as you know, we were trying to make it as clear as possible that no new rates, that the existing rates that were in effect before we ever filed the rate case would stay in effect until September 1, 2020. And that was, I mean, and this was responding to a request that was made to us to delay the whole case after we had already after it had already been tried and argued and was ready for a decision. And so we declined to go along with that, but we did, as an alternative, propose to delay any increase. We certainly did not, in those two sentences, we did not waive our right to, and could not have, and it would have been bad lawyering on my part to, you know, by the way that was described, somehow waive our right to put, the company's right to put rates into effect under bond we didn't know what the Commission was going to rule at that point. There had been no ruling. We had no idea what the result of the case was. We were trying to emphasize that in order to help customers deal with the difficulties caused by the pandemic, there was going to be a delay in any increase. We did not, in that, it is a stretch for Mr. Hall to suggest, and it's a misinterpretation by him to suggest that was a waiver by us of any rights to put rates into effect by using the rates under bond provision of
I believe just this week, Blue Granite filed a conditional petition for approval of an accounting order. I know that it was just filed. Is that, I reckon I have questions whether or not we can bring that up in the context of this, these oral arguments today. Do you have a position on that?
Yeah, we're certainly not asking the Commission to rule on that. I mentioned it in my letter or email to the hearing officer, Tuesday, because we think it's relevant to the discussion, and just wanted y'all to be aware of that we had filed that, and that deferral petition requests a regulatory account be approved so that the company could book the difference between the rates that, because of the stay, we will put in rates that are different from the rates that we had proposed to put into effect secured by the bond. So that's for an issue for another time. We just thought that it was relevant. What we hope is that the commission will move quickly to remove the stay and allow the company to go forward with putting the rates into effect on one. And we won't need then to do the deferral accounting and all of that.
Well, can I just ask, and I think I understand the petition, but I just want to ask a pretty basic question about it. The amount that is cited in that petition of like $5,900 or something a day, that is I'm going to make a statement, and you can tell me if I'm right or wrong, if you would. But it's my understanding that that's the difference in rates that were approved by the commission in its order, and the difference in what the company is requesting to put into effect under bond.
With one clarification, it's the difference between what the commission approved on reconsideration.
Okay, thank you.
You changed your rulings, and the rates that the company is proposing to be put into effect secured by the bond. That delta would go, if the deferral petition is, as we've described it, if that ends up being put into place, that's the money that would go into that regulatory asset account.
Okay. Mr. Chairman, that's all I have at the moment. I may come back, though. Thank you, Mr. Ellaby.
Mr. Chairman.
Thank you. Commissioner Urban.
I just lost my video because my battery on my iPad ran, so I'm recharging, but I'm with you and I'm listening.
Okay, we got you.
I have some questions. For Mr. Ellaby at this time.
Go right ahead.
Ellaby, thank you for your attendance and your patience with us. I wondered if you would address the fact that in our directive approving the surety in the bond, we failed to comply with 585240D because we didn't specify the refund parameters. Would you agree?
No, I don't agree. I believe that would necessarily have to be done after an appeal. If the appeal, because there are lots of different, as you are well aware, lots of different ways an appeal could come out, and so there would have to be a process of evaluating when the court ruled, what impact did that have on the rates that the commission had approved versus the rates that were put into effect. That language you're citing there will come into play, a year and a half from now, or however long it takes the court to get to it and makes a ruling and then remands it. And if refunds are due after that process, this commission will have to consider that and issue an order providing for the refunds.
All right, sir. I'm going to ask you just by way of context. The company asked for a 56% rate increase during a COVID pandemic. Do you think that that's fair, just, and reasonable?
Well, first, yes. The rates that we proposed in the case, which was filed before COVID had come to this country, but we believe and continue to believe that the company's spending, capital spending and expenses absolutely justify the increase that we asked for. So, yes.
But you would also agree that when you, as you said, when you asked for it, we weren't in a COVID pandemic. We weren't under a governor's emergency declaration. So things have changed since you filed a rate increase. True?
Those things have changed, absolutely. And the company responded, as I discussed earlier. The company took significant steps very early in the process to try to lessen the impact and to keep our customers from being disconnected. I mean, that's an important thing, the water and sewer customers, yeah.
And I thank the company, and I know the commissioners, all of the commissioners appreciate the company considering the devastating effect that COVID-19 has had on our state and our workforce and our ratepayers, and many of whom, I think 17% of all South Carolina residents are age 65 or older. So you got, as we heard at our public hearings, many, if not most of them, are on fixed incomes. 1 in 6 children in South Carolina are food insecure. And as we heard earlier from the Consumer Affairs representative, 52% of South Carolina tenants are now at risk of eviction. And 26% of South Carolina residents have some form of disability or special needs. I think we have to consider all these things when we look at imposing a 56% rate increase under bond, because things have changed. In fact, they're changing for the worse, because now the Supreme Court has lifted their ban on evictions. The Congress has failed to fund another round of unemployment benefits, which have run out at the end of August. And so rather than getting better, things are actually getting worse. The unemployment rate is going up. We have thousands of people out of work, many of whom will never return to their former jobs, sadly. Small businesses are struggling. So, and you have to look in the context and the background. Don't you think that would be a relevant consideration for us to consider all these things?
Well, Commissioner, at this point, I don't think those things are available for you under the statutory framework that we're operating in. I think the Commission is to be commended for its efforts in encouraging utilities and actually getting all of the state's utilities to respond and take some of the measures that have been taken. I think the Commission was, early to raise the alarm about these issues and wrote the letter to the governor and to the General Assembly. But with respect to what's before you right now, there is clear statutory provisions that limit your ability to consider those things in the context of what's before you now.
Let's talk a minute about, I believe you were present with Ms. Catherine Hagel, who's Vice President and COO of parent company for Blue Water. I believe that's Corix. Is that correct?
They're headquartered is the parent company.
Yeah.
Yes.
Yeah, they're in Vancouver, British Columbia. And so she had a allowable ex parte hearing when the name change was proposed, when Blue Granite was in the process of changing their name from Carolina Water to Blue Granite. And at that presentation, we're given some handouts, and I saved the handout, and I was impressed with the presentation, but I call your attention to the Blue Granite mission statement. And I'm going to quote now from the mission statement: to improve the quality of life for our customers and communities by providing safe, reliable, and cost-effective water and wastewater services while promoting environmental stewardship. And it goes on to say that every day, Blue Granite works to improve the lives of our customers. We pride ourselves on being an active partner with the communities we serve, end quote. Now, in the spirit of Blue Granite's mission statement, which I just read, don't you think under these terrible circumstances that we find ourselves in now as a state, where your Blue Granite's customers are suffering in so many ways, don't you think to live up to that mission statement that Blue Granite should consider accepting the rate increase that the commission found was fair, just, and reasonable, and put that into effect if they choose to on September 1, rather than impose an additional burden on your customers and by implementing a larger rate increase on their bond? Don't you think that would be consistent with your client's mission statement?
Commissioner, I appreciate the question. That mission statement mentions fair, reliable, environmentally appropriate service.
That's right.
In order to do those things, the environmental stewardship. Yeah, I actually was not present at that ex parte briefing, but that was before my time representing the company. But I fully agree with that mission statement, and the company needs revenues in order to meet its obligations as a public utility to provide service in the way it's supposed to be provided. To address some of those things that Mr. Moore talked about, the company it has to bring in the revenues, and so we've taken significant steps to respond and help our customers respond to the pandemic. But at this point, we need to move forward and get revenues coming in order to meet those other obligations.
Well, and I think you're absolutely right that in order to improve the quality of service and customer service and provide safe and reliable service, you do need a certain level of revenue. But what I'm asking the company to do, if they really are, and I think what Ms. Hagel said, they're starting over and it's a new day. If this is a new day, I hope that she and Ms. Lisa Sparrow, who's the president and CEO, will reconsider this, and I would implore them and plead with them to reconsider imposing rates under bond during a COVID pandemic, where so many of their customers and ratepayers are facing being evicted, being unable to buy prescription medication, being unable to provide food for their children, and so this is their opportunity to show us that yes, things really have changed, that the bad reputation that Carolina Water carried all those years is behind us, and this is a new day. And they're going to work with the commission. They're going to work with their ratepayers, not disconnect them, and hopefully we'll have a safe and effective vaccine sometime at the end of this year or next year, and then they could reconsider the position at that time. Why wouldn't your client consider that, Mr. Elder?
Well, Commissioner, those things have been considered by the company. The company didn't take this action lightly, and I'm repeating myself, but the company believes that it's taken significant appropriate steps to try to help customers. It is a new day with respect to the way the company's approaching these things, but it's not a new day with respect to aging infrastructure and issues that need to be addressed that cost a lot of money. And those things can't just be put off without causing more problems, more service problems for those very same people you're talking about. So I think the company has given serious consideration to the things that you're talking about.
Those are all the questions I have, Mr. Chairman.
Thank you, Commissioner Urban. Commissioners, any other questions for Mr. Ellerby?
Mr. Chairman.
Mr. Chairman.
Commissioner Belser.
I'll go with Mr. Whitfield.
Okay, Commissioner Whitfield.
Thank you, Mr. Chairman. And, I know Commissioner Belser will have smaller follow-up, but mine shouldn't take that long. Chairman, Mr. Ellerby, Commissioner Irvin had an exchange with you, I guess kind of sort of a plea, if you will, a plea back to you and to the executives of the company. But as you stated prior to him saying that and during it, you've honed in the reason we're here today, and it deals with the bond. And as you know, and others know, when we issue a final ruling, a final order in a case, and the applicant appeals, we don't know how long it's going to take for the Supreme Court to hear that appeal. We don't know what the outcome will be, and we don't know how long the ratepayers will be in this circumstance, if you will, with rates under bond, because, as you've stated, the matter going forward will be out of our hands. So in that light, can you get just a little, not technical, but numeric with me if you could, and could you give me the numbers that you used to calculate the $5,270 per day figure in your petition for the accounting order?
Commissioner, I can tell you as I discussed with Commissioner Belzer, that's the difference between the rates the Commission approved on reconsideration and the rates that we intend or would like to implement as protected by the bond. Exactly how that was calculated, I don't have. That was calculated for us as we put it in the petition. We can certainly, maybe in the context of that deferral petition, provide some additional information. We would expect to be providing that information to the ORS, and if they would like to participate, to the consumer advocates, so they can understand how we did that calculation. That's as much as I can tell you today.
I think you referred to that figure as maybe in previous exchange with Commissioner Belzer as the delta.
That's right.
Well, if you could do that, if you could provide that, Mr. Chairman, I would like to ask that we have that included in the record.
We'll provide a late filed exhibit, Mr. Chairman. Would that be satisfactory?
Okay, we'll.
Or I can't hear the chairman.
Well, I'll not talking. We will accept a submission, we're not going to call it a late file exhibit, but it's a submission on that for Commissioner Whitfield.
Thank you, Chairman.
Thank you, Mr. Chairman. And Mr. Ellerby, kind of just following up with that, how much are you, I guess you kind of said you can't ask, but I'll toss it out there if you know. If you don't, I'll look at your late files. But you know how much you're asking for in carrying costs? And do you propose a cap on the total amount that you seek?
We have not specified the carrying costs that we're seeking, and we have not proposed a cap, as you mentioned. That would depend on, I mean, in this case, it depends on how the Commission acts on the matter before you today. If y'all lift the stay, we don't even need action on the deferral petition. If you keep the stay in effect, I mean, just so that, and there may be people listening who aren't as familiar with it as y'all, but one reason that rates, the provision, the General Assembly and a lot of other states have provided mechanisms like the rates under bond mechanism is that if the company prevails on appeal, and rates haven't been put into place under bond, the company can't go back and recover those revenues that the appellate court decided that the company was entitled to. So this mechanism of rates under bond is part of the state of South Carolina determining how, what mechanisms would be put in place to allow for the companies to recover their appropriate constitutionally protected return on their investment and their expenses under the Hope and Bluefield cases. So there's constitutional underpinnings with respect to the rates under bond process that shouldn't be ignored. To get back to your question, if y'all don't do that and the accounting order stays in place, it could be in effect for a good long period of time, because the court, when we initially calculated the amount of bond, we used 18 months as a guide for when the appeal would be decided. But that's up to the Supreme Court, and we can't really control that.
Correct. Thank you, Mr. Ellerby. That's all I have, Mr. Chairman.
Thank you, Commissioner Whitfield. Commissioner Belser.
Thank you, Mr. Chairman. Mr. Ellerby, something that I had intended to ask earlier and I failed to, and I apologize, but I asked Mr. Hall if the parties had tried to discuss any resolution of their with regard to their letter. Now that this conditional petition has been out there, and I think that we understand some of the issues more, is there any chance that the parties could discuss to see if there's a resolution?
Well, I'm glad you asked about that. I got a voicemail message on the day that petition was filed from Mr. Hall, and by the time I tried to return it, which was almost immediate, he was on the phone with Sam Welborn, and before we could explain the conversation, or before Sam could fully explain the conversation to our clients, the letter was filed on the DMS, so that there wasn't any back and forth. They did touch base with us before they filed it, but it was right before they filed it. Based on the back and forth, I mean, we're always willing to talk to folks, but I don't see, Commissioner Belser, I don't see much likelihood that we will be able to work something out with them. But we'll discuss that with our client, certainly.
I see several different scenarios of possibilities that I think could just be helpful to the parties and to protect the party's interest and to protect the consumer's interest. And to the extent that the parties would discuss this further, I would encourage that. I mean, we'll certainly make a decision. It's not going, somebody ain't going to be happy. Probably, but if y'all can come to a resolution or a proposal that we could entertain, I think that would certainly go a long way to help all parties involved. It's just a suggestion. I can't mandate it. I do have a question. This is maybe a little off the wall. Mr. Ellerby, do you know if Blue Granite applied for any of the COVID funds that the federal government had released? And the reason I ask that is in your pleading and in your statement today when you said that the company had foregone about $2 million by delaying implementation of the rates. I was just curious.
I'm not aware of any. You're talking about the payroll protection plan program or something like that, the
Right.
PPP.
And I don't even know if they're the size that could do that, so.
Yeah, I don't know. I'm not representing one way or the other. I just don't know.
I understand. That probably doesn't come up in the context that y'all been talking. I appreciate it. Mr. Ellaby, thank you for your presentation today. I appreciate your responses and your indulgence in my questions.
Thank you. Mr. Butler has a question, I think.
Yes, sir. Thank you, Mr. Chairman. Good afternoon, Mr. Ellaby, or good morning still, it appears. Beg your pardon. I did have one question for you in follow-up. You made mention a little bit earlier of the length of time that it might take for the Supreme Court to consider this case should you appeal to it. Do you know if there's any mechanism to ask the Supreme Court for an expedited review? It's been some time since I've had contact with the court, and was just curious if there's any sort of expedited review procedure that the company might be able to ask for.
Mr. Butler, it is possible. People have done that recently, and there are a number of election cases, for example, and things like that that the court has allowed. I've been involved in some other cases where people have thought that their case was so important that the commission should take it in its original jurisdiction, and the court has been very reluctant to do that. Under the circumstances of this case, I think it would be highly unlikely that the court would agree to expedite this appeal.
I see. Okay. Thank you very much. That's all I have, Mr. Chairman.
Thank you, Mr. Butler. Commissioners, any other questions of Mr. Ellerby? If not, Mr. Ellerby, thank you for being here for your comments. Okay.
This is Mr. Knowlton. Are interveners permitted to ask questions?
I'm getting to you in just a second, Mr. Knowlton. Thank you. But you're not going to ask questions. No, you are able to, if any other of the interveners, ORS, Mr. Knowlton, or York County want to make a statement, you may at this point. But no, the questions are not in this oral argument portion. So,
okay, my
ORS
question
or
was
Mr.
whether I could ask Mr. Ellaby about his testimony. I'm sorry.
No, sir. Thank you. Okay, ORS or Mr. Knowlton or Mr. Kendrick from York County, any statement that you would like to make? This is your time.
ORS has nothing further.
Thank you. Okay.
Mr. Knowlton would like to comment.
Okay, Mr. Knowlton, go right ahead.
Thank you. It seems to me that in this time, where not only the citizens of South Carolina, but also the greater part of the world are paying a huge price, that the company should be making some concessions as well, and that for them to insist to full speed ahead and torpedoes shows their true colors. Thank you. That is all.
Thank you, Mr. Knowlton. Mr. Kendry?
Thank you, Mr. Chairman. Just want to appreciate the Commission's consideration of this, the tension that's been created between some moral issues and the legal issues, and appreciate your deliberation on that point on behalf of York County. Thank you.
Thank you, Mr. Kendry. Okay, Mr. Hall, have you got any reply?
Yes, Mr. Chairman, thank you. I guess first I just want to say to Mr. Ellaby, Mr. Wellborn, the filing of that letter was never meant to close the door to any discussions with the company. In fact, I let them know that letter was going to be filed. And that we still wanted to discuss those options. And I don't think the content of the letter itself actually, closes the door on anything. With that being said, I think it is important to realize here that COVID-19 is certainly a drastic change of circumstances for the Commission to consider. And I think I agree with Mr. Ellerby that there is no conflict between the statutes. They work together. Another part of statutory construction is that the intent of the legislature controls. I don't know how you could look at 58.5.320 and not realize that it applies perfectly to this situation. It allows, just read it again, that the commission may at any time, alter, amend, or rescind a prior decision. 58.5.290 specifically says that they can set, if they find that rates or otherwise are unjust, however or whensoever they shall have theretofore been fixed or established. I mean, these statutes, I think, give, plenty of authority to the commission to look at these issues with fresh eyes, with the changed circumstances, and alter them if they so see fit. Let me say, I would like to address a couple specific comments as well. The department disputes that this was a voluntary delay from Blue Granite. I mean, as we've said before, there was a serious risk that the legislature or the governor might put in an indefinite delay. They didn't, but Blue Granite couldn't risk that, so that's why they made the offer. I also feel that words have meaning. There was no point to say that whatever rates are set by the commission will be implemented. Blue Granite said, we'll put in whatever we want at the time. They wouldn't have said that because clearly that's not as persuasive. Another issue that keeps coming up is that Blue Granite is somehow foregoing $2 million in revenue. I think one thing to understand is that the commission's original order did not deny any relief to Blue Granite. The original order provides an additional, I believe it's $4.9 million, almost $5 million in additional revenue. So we're not talking about, after the original hearing, they got nothing. $5 million in additional revenue. As far as foregoing $2 million in revenue, this isn't money that Blue Granite has. In order for them to forego $2 million, that assumes that they would win on appeal. There's no guarantee of that. It also presumes that they could take that extra $2 million and somehow earn more than 12% interest on it in the meantime, because that's what they're going to have to pay it back. So I think it's misleading to say that they're foregoing $2 million in revenue. And for that same reason, to the application for deferral, we would disagree that it would be a taking, because again, this is not money that Blue Granite currently has. There's no guarantee that they ever will have that money. So I'm just, going through my notes, if you bear with me. So Mr. Ellerby also commented that, this is our letter is not the proper forum, that there's no motion or effort, that he couldn't file a petition to have these issues raised. And I would ask then under what mechanism could the commission implement these statutes? I believe they could do it on their own free will. I believe that any consumer or any customer of Blue Granite could file any petition motion. There is no trigger. The statute's not explicit. And again, I believe the commission could take it upon itself to look at the change of circumstances and apply 58.5.290 or 58.5.320. I think for that very reason, I would say too that we're not disrupting any orderly process here. I think that the statute very clearly, again, lays out a process for reconsideration, for raising these issues. And to that point, the statute, as I read earlier in my opening statements, provides means for requesting rehearing, for appealing decisions. Talked about the difference, what is the difference between a directive and an order. Parties have a right to appeal, and I believe parties should not be expected to know that the directive triggered the appeal period. Without more, any party could, when this order comes out, or if the commission decides to issue an order here, could decide to appeal it, request a rehearing, and I think the statutes allow that. Regarding the refund, I believe Mr. Ellerby said something to the effect of that it would the refund parameters would have to necessarily be addressed on appeal. We respectfully disagree with that. We believe that the statute includes several statements about the refund, explicitly says that it needs to be addressed by an order, whether it's speculative, that if a refund's required, it could be addressed later. However it is, it needs to be addressed. If you look at past commission orders, they do defer the issue typically, but it's addressed. And I believe it's addressed because the commission recognized that the statute required it to be addressed. Again, I guess I'll close by saying that Blue Granite has been provided $5 million in additional revenue. In theory, they could implement that. They could implement it under bond while they appeal and request more from the Supreme Court. COVID-19 has provided, again, unprecedented times that we believe the commission should use the authority that it has previously exercised to alter or amend previous decisions. That's all I have. Thank you.
Thank you. Commissioners, any final questions of anyone that you want to ask? Okay. Hearing none, I want to thank all the parties for being here today and for your statements, your comments, your arguments, and we appreciate you answering the questions of the commission, and appreciate everybody's participation and bearing with us in this virtual hearing. And if there's nothing else from commissioners, then we are adjourned. Thank you.
Mr. Chairman?